Right, so we're looking at criminal courts then, and the first area we'll look at is mode of trial. So this question, mode of trial, what it actually means is working out where your trial is going to be heard. Okay, so we've got various criminal courts throughout the country, and we start off either with the magistrates court or the Crown Court if it's a criminal offence. So we need to know where our trial is going to take place. In order to decide that, we have to look at what crime you've actually committed. So as you can see, the left-hand side, you've got your categories of crime. There's 3 types of crime in England and Wales: summary, triable either way, and indictable. Okay, now if you want to just add in your boxes there then, if you've not done so already. So summary offences are low-level offences, so they're what we call minor crimes, and they are dealt with at the magistrates court. Okay, so if you want any examples of summary offences, it could be speeding, for example, any low-level offences such as like assault or battery. These are classed as minor offences or low-level crimes, so they're dealt with at the magistrates court. Okay, as long as you've got one example of each, you are fine. So you wouldn't even need both of those, just see what you prefer. Our second types of crime are triable either way offences. Now these are known as middle ranking crimes, right? So they're in the middle. They're not really serious, but they're not minor. So they're middle ranking offences. Now they are dealt with either at the magistrates or the Crown Court. It depends on what's gone on really. Examples of things that are triable either way. Theft is, as long as it's above £200. So if it's 200 plus, it'll be classed as triable either way. But anything that's under £200, it won't be. It'll be classed as summary. Okay. Indictable offences then, these are your major offences, alright? So they're really serious, and they're only dealt with at the Crown Court. And obviously everybody's heard of this one. Your most clear example is murder, alright? And that's dealt with at the Crown Court. Now, because we know that summaries just go to that one court, that's fine. So any summary crime, speeding, assault, battery, any low-level driving offence will class as summary, and it goes directly to your local magistrates, right? Indictable offences, because they're so serious, they get dealt with by the Crown Court, because the Crown Court has got unlimited powers. Okay, so that's why we allow them to go there. The triable either way ones, because we've got the option magistrates or Crown, the rest of this question is you actually telling the examiner how we decide which one of those 2 courts your offence is going to. So you started off by explaining the 3 types of crime that we've got in England and Wales: summary, triable either way, and indictable, and that's your first 9 marks. But the rest of your answer comes from saying, right, okay then, we've got triable either way offences. They can go to either. This is what we need to do then to decide where this case is going to get heard. Okay? So, the first thing that happens then with a triable either way crime is we have what we call a plea before venue. Right? The plea before venue enables you as a defendant to either plead guilty or not guilty to the charge. Remember, this is just for triable either way offences, just for middle ranking crimes like theft, actual bodily harm, for example, criminal damage. So it allows you to plead guilty or not. If you do plead guilty, the magistrates court will automatically take it, right? But they might have to send it to Crown Court. Even when they say yes, they might still then have to send it. If you want to put your reason here next to the example, why? Because they might not have enough sentencing powers. So they might not have enough sentencing powers. Okay, so if I plead guilty to theft, they will say, right, Ravina, you've pleaded guilty, we're going to take your case straight away. But then as the case unravels, it might be, oh, actually though, we want to sentence you a little bit harsher than what we're allowed to, so we're going to now pass it on to the Crown Court for sentencing. So they can do that should they feel like they need to. Okay, so that's just if you plead guilty, they'll take it if they can. If you plead not guilty, a mode of trial happens. Now, a mode of trial is basically where the magistrates work out, can they take your case, in that sense. So they'll sit down, look at your case, look at the details and think, right, can we take it? Remember, the magistrates are limited in their powers. Okay, they can only sentence you to 1 year in prison for 2 crimes. If it's your first crime, so if it's just like one theft, they can only sentence a maximum of 6 months. In terms of fining, they can only fine up to £5,000 unless it is a level 5 summary crime, and then they are technically classed as being unlimited in that sense. So your magistrates, with the level 5 offence, so level 5 summary or level 5 tribal either way, they are able to therefore increase that. So you've just got to be aware. Okay. Right, so it only takes place if the defendant pleads not guilty, and it's so the magistrates can work out, are they the best people to take your case? So you've got a few things down here that we'll look at. Now, realistically, as long as you've got 2 or 3 of these and you've explained them, you're fine. So don't panic if you can't remember all of them. Right, so I'll take you through them and then you decide which ones you want to remember. So first of all, they look to see if their sentencing powers are sufficient. That means enough. So if they want to sentence you more than 1 year, so above 1 year, they don't have enough power. So they have to look at what powers they've got and are they enough powers in order to sentence you for that offence. Okay. Second thing they look at then, the nature and seriousness of the crime. Alright, so they have to have a look at what you've done and how you've done it in that sense. How serious is it and how have you done the crime? Is it that you've done it on the spur of the moment? Is it that you've used weapons? Because the more serious it is, the less chance the magistrates have got the ability to take it. Alright, so if it's really serious, magistrates can't take it. So they have to have a look to see how serious your offence is, because too serious means they can't have it. Thirdly, then, they will also look at whether you are legally represented. So that means whether you've got a barrister or solicitor. So if you do have some legal representation, it's more likely that you'll probably go to Crown Court, because it's not often you see barristers or even solicitors in the Magistrates Court. It tends to be in the Crown Court. So just add at the side of there, if you've got a barrister, it's more likely that it'll be at the Crown Court. Fourthly, then they'll look at your previous convictions. So they'll see, have you got previous convictions? If you have, it's less likely that they're going to be able to take that case, because if you've got previous convictions, you're clearly not learning, are you? So if you're not learning and you're committing more crimes, there's more chance that they are just going to say, no, we can't take it, it's too serious, we need to send it to Crown Court. And then finally then they'll look to see what the prosecution wants. So the Crown Prosecution Service, if they would like you to have a harsher sentence, it's possible that then they will need to look at that and take it to the Crown Court. So these are sort of factors that the magistrates will look at before deciding if they can take your case. So there's 5 there. Make sure you've got 2 or 3 of them in depth, and then you'll have enough there in order to get your marks in the exam. Okay, turn over. Right, so now we've got reasons why the magistrate should refuse to take your case. And again, the same thing, 2 or 3 of these. So first of all then, if it's complex law or facts. So if the details of the case are really, really complex, there's a few of you involved, the law that they would need to be applying is really, really serious, then they might as well just pass it to the Crown Court. They're not allowed to take it, because remember, your magistrates don't have legal qualifications. That's the point in them. So if they're having to apply a really intricate section of the Theft Act that's really detailed and they don't understand it, then they should be passing it on. Okay, they shouldn't be doing anything about it. Secondly, then, if it involves a breach of trust. So if you've got some trust upon you that's been given to you, so it could even be via your job, for example, you've breached the trust that's with you. So like with me, I start nicking the laptops or taking loads of board pens home. I'm breaching the trust that's upon me via college. Or it could be that just you're in a position of trust, so you're looking after somebody that's elderly. Anything really that means that you've breached the trust that's upon you, it will be too serious for the magistrate to deal with. Thirdly, the crime was committed by an organised gang. So if it's on the spur of the moment and it's something that you've not really planned, they might sort of take that in your favour in a sense. But if you've organised it and it's a gang that's doing it, that makes it worse automatically. Instead of it being one person, there's a gang of you, it does make it worse. So technically, again, that is too serious for the magistrates to take. So as a result, they'll decline it. And then finally, the amount involved is greater than twice the amount the magistrates can fine. So normally, unless it's a level 5 offence, your magistrates can fine £5,000. So if it's more than twice that amount, so if it's more than £10,000 involved within the case, that therefore means that they won't be able to do anything about it. They'll have to pass the case on. So these are all reasons why they should decline your case. Okay, so you've pleaded not guilty at your plea before venue, and they've looked at the reasons why they should be able to take it. They've looked at the reasons why they need to refuse it. The last thing then is for the magistrates to get in contact and say whether they can take your case or not. So if the magistrates turn around and say no, we can't take your case, you would automatically have to go to the Crown Court for your trial, and you'd have a full trial with a jury and then be sentenced. Okay, probably a couple of weeks. If the magistrates decide they accept, then you choose where you go. Right? So the defendant chooses whether you go to magistrates or whether you go to Crown. However, a note for you to add on the bottom, I'll just put warning. You are warned as a defendant, even if you choose, right, okay, then I've got the choice, I'm going to stay at magistrates because I know they can't sentence me very harsh. Even if you choose to go to the magistrates, you could still end up being passed through to Crown if they deem that actually they need to fine you a lot more or they need to sentence you a lot more. So just be aware that even if you choose to stay at the magistrates court, realistically, you have still got the possibility that you could get sent up to the Crown Court. Okay, so that's your final bit to get your final couple of marks. What happens when they accept it? What happens when they decline? So accept, you choose, but you're warned that you could get sent to Crown anyway. If they decline it, there's no option. You have to go to Crown Court. So they're just examining everything about your case. Alright, so that's mode of trial. It's how we decide where each case gets heard. So summary crimes are little, they go to the magistrates. Indictable crimes are very big crimes, they go to the Crown Court. And then your tribal either way crimes, because they're middle ranking and they can go to either, you've got a lot then that you need to discuss. Things that they'll look at and then things that they'll have to say no for. Okay, so I'll just add at the bottom of the page then what you've got to make sure you do. So first of all, you need to include your categories. Explain to me the 3 types of crime. Give me examples of them and tell me where they're going to be heard. Okay. Then secondly, you need to explain that for a triable either way crime, so only triable either way, we start off with a plea before venue and see whether you plead guilty or not guilty to that crime. If you plead guilty, it will automatically go to the magistrates unless they've not got enough power. Thirdly then, we could have a mode of trial. So again, a mode of trial is only for triable either way crimes, and it's only if you plead not guilty. We'll have the mode of trial. And then what is the mode of trial about? We'll look at factors as to whether we can take the case on. So give me a few things that we'll look at to decide whether we can take the case, and then tell me reasons why we might need to decline it. Yep. And then finish off with the result. So what happens when they accept it? What happens when they decline it? Okay, and then that's you've got everything that you need for your 18-mark question. Okay, all right then, that's mode of trial.